So welcome to Criminal Proceedings Week. If you have not subscribed, please subscribe, like, share, and comment. So as you can benefit from all the recaps that will come after finishing category A, because we want to give you a full recap, which will basically remind you of all that we have covered from term 1 to term 2. Each course will be a 1-hour video that will remind you everything that we have covered when we started reviewing this workshop up to the present, so as we can give you a very good boost in your preparation for your oral exams, because I understand that most of us we have forgotten the principles, for example, where we started from. So you need to be reminded, and then you can go and fill in the details or the full structure. So we are preparing a 1-hour video for each category A subject that will cover term 1 both 2 weeks and term 2 both 2 weeks, making 8 weeks. 8 weeks times 2 workshops each, that becomes 16 workshops. So it will be an analysis of 16 workshops. But let us first deal with the task before us, which is trial proceedings in the High Court. So this module will equip students with skills required to manage and conduct trial proceedings in the High Court. The skills shall encompass unique aspects such as pre-taking. So we looked basically at the process of pre-taking, and the locus classers case is Adan versus Al, which we have looked at, and it can be an oral question, and they want you to take you through pre-taking. But the locus classers case on pre-taking is the case of Adan versus Republic, which gives you a detailed structure of how the judicial officer should conduct pre-taking. From the point of introducing the accused to court, asking him his name, which language you understand, reading the charge, asking whether you understood the facts, how do you plead, and how do you record it, all that process in Adan versus Al. So the skills shall encompass unique aspects such as pre-taking, the selection and role of assessors. We have looked at the role of assessors, of course, on the Trial on Indictments Act, of course, read together with assessors rules, and also the case of Geoffrey Tinkamarirwa versus Uganda, which basically gives you an analysis of the role of assessors. So you know that any trial conducted without assessors is a nullity and can be a ground of appeal. So there must be at least 2 assessors on each case, of course, as provided for by the Trial on Indictments Act, read together with assessors rules. Then we proceed preliminary witnesses, preliminary hearings. Of course, preliminary hearings can include trial within trials. A trial within a trial arises where, for example, you find that the prosecution intends to rely on the confession, but the defense is objecting to the confession. So once that happens, the court conducts what we call a trial within a trial, test on the truthfulness of the confession. That's what we call, that can be some of the pre-trial hearings. Then examination in chief. I believe that we are all now masters in examination in chiefs, as well as cross-examination and re-examination. As governed by the Evidence Act, of course, cross-examination, examination in chief, is by the person who brought up the witness. That's what we call examination in chief. Cross-examination is the opponent counsel. Re-examination is now by the person who brought the witness. I hope you understand these terms, but if you don't, you can visit the Evidence Act, because they are defined. Then we can proceed and we look at demonstration of tendering in of exhibits and export reports. So you know that you can only tender a document by the person who authored it, and still that's provided for by the Evidence Act. You can tender a document by the person who authored it. For example, expert reports, physical objects, demonstration of objections to admissibility of evidence, for instance. So how do you object to admissibility of evidence? I believe that you have seen moots once that the person wants to tender in the document, you just rise and say, I object, my lord, the tendering of the document, and then you state your reasoning. Then of course the judge gives ruling to that, whether it's admissible or it's not. Extrajudicial statements can include confessions. Then charge and caution or extrajudicial statements. So basically, charge and caution statements are all those statements which are going to be used in court. It can also be a confession. It can also be a written statement, any statement, as long as they are saying that anything you say can be used against you in court. Then postmortem reports, medical examination reports, etc. Different types of submissions, including a no case to answer and final submissions. So once the prosecution has finished leading its witnesses and adduced all its evidence, the defense does what we call submissions for no case to answer. So basically they are saying that the evidence that has been adduced by the prosecution is not adequate to put our client, or maybe the accused in this case, on his defense. So the prosecution will also submit that they laid enough evidence that warrants the defendant, or maybe the accused in this case. I can say we don't have a defendant in criminal proceeding. We have the accused. That the accused to be put on his or her defense, and then the court makes a ruling. So where the court finds that the prosecution did not lead enough evidence, the matter is dismissed at that very point. Different types of submissions, including case and final submissions. Final submission is when the accused has been put on his defense. That's where we go to final submissions. Different types of rulings, summing up to assessors. So how do you sum up to assessors? We have looked at the case of Tinkamarwe. And then judgments, alloctus. We have, of course, the defense saying that the accused should be given a light sentence, whereas the prosecution says the accused should be given a heavier sentence. And sentencing and termination of proceedings by the DPP, the skills for the above procedures will be imparted to students to role play to demonstrate the intended outcome of the trainings. So most of the work here is through role play. So develop the ability to institute criminal cases before the High Court, develop the ability to conduct trials before the High Court, and identify and deal with issues that arise from the trial process. Learning outcome. At the end of the workshop, you should be able to institute criminal proceedings before the High Court. So we say that in the High Court we proceed by an indictment. In the High Court we proceed by what we call an indictment, but there must be summary of the case, or what we call committal proceedings. Then read evidence during criminal trials. Reading evidence is just how do you tender in documents, how do you examine chief your witnesses. Tender in exhibits during criminal trials, object to evidence produced by the opposite party. So you can object to the evidence during the tendering it in, like the way we always do in moots. I object, my lord. On what grounds? On the authenticity of the document. Identify and deal with issues arising from the trial process. I think we have that case of Peter Ojangare versus Uganda on conflict of interest, where the law firm wanted to represent a client whom they had worked with the employer to dismiss. So that was called to be a conflict of interest. So that's one of the issues, not overcharging your clients. Of course, doing due diligence. We have that case of the hospital, Chimongez, where the person sued an non-existing party. So make sure that you do proper due diligence. Then the police statement of the complainant. Which said that on the 15th July 2024, I had gone to Grand Royal Park Hotel in Muyenga as a guest. I had come on a business trip. I had in my possession USD 45,000. I obtained the money from the sale of my bus. I wanted to exchange my money into Uganda shillings in order to buy an apartment. The house I wanted to buy is owned by Nimrod. We had already agreed on the price of Uganda shillings 210 million. At around 9, I asked the hotel manager to direct me to a forex bureau. The manager told me to inquire from the banks in Gaba Road. I started to move around looking for a foreign exchange bureau, but I could not easily find any. So I went to the bank on Gaba Road, and I saw 2 armed police officers deployed to guard the 2 banks that were next to each other. When I inquired from the police guard at the bank about the possibility of going a forex bureau, in turn moved and spoke to the other officer who was guarding the next bank called Islamic Bank. They spoke for some time as I waited nearby. They spoke in a local dialect that I did not understand. I then saw the police after who was guarding the bank talking out his cell phone and spoke to someone for about 10 minutes. When he concluded the phone call, he approached me and offered to accompany me to a nearby street from where I could be helped. We went through a corridor, and at the end of which saw what I thought to be a police pickup truck. A police pickup truck approaching us. The registration number of the truck was UPA. One of the occupants of the car, a man who claimed to be a foreign exchange broker, mentioned me to board the vehicle. While inside the car, there was another man seated at the back. The car windows were tinted. I just said my piece I was driven through many places. The broker and another man dispatched with my money. As soon as the duo disappeared, the corridor driver, I was hesitant because I could make up my mind about what to do the man. I tried to seek help from other people around, and when I observed the surroundings, I realized that I was in a place called Mukono. So basically here the major fact we have, the major offense we have is aggravated robbery. Which is one of the major offenses. So you can also look at abduction and maybe causing grievous harm. Those are the ones I have been able to identify from reading that statement. Then we can look through the statement of the witness, statement of the suspect. The above particulars and address are true and correct. I do wish to say that I work for Uganda Police Force. On the 16th July 2024, I had to rush to see my sick mother in Muyenga. I stayed there for some time. It is true that my bosses did what they are talking about. I have not seen from anyone. The money was given to me at my workplace as an appreciation. I don't know anything about the allegation against me. That's what I can state. So I think that he also brings about the defense of alibi. We have the statement of the investigating officer. You can also pass through it. Attach the medical reports. Examination on arrest by the police officer. Official examination arrest by police officer. So we have those documents. So workshop tasks. Assume the role of the chief marking and above file have been submitted to you. DPP. Peruse the case file and do the following. Identify the offenses. So basically we have aggravated robbery. You can talk about abduction, and then grievous bodily harm. So evaluate the evidence. Of course, we're going to continue evaluate the evidence like the way we have always been doing. Then the event, we shall draw what we call a summary of the offense and an indictment. Assume the role of the state attorney and defense attorney and lead evidence in chief, and examine the complainant and the investigating officer, especially regarding the recovery and custody of the exhibits, and have them tendered in court. So basically, here I have to ask questions. If you're about the state attorney, what's your name? If you're the state attorney, what's your name? What were you doing at this date? Where were you? Like what you have always been doing. I think now you have understood the art of cross-examining and examination in chief and tendering in document. But if you have not, then you can come into our mentorship program. We shall be able to take you through, because these are the questions they will be asking you in your oral exams. So you can contact me on 07567678284 WhatsApp number. Then members pay monthly subscription fee. So in a role play involving a judge and respective attorneys in court, conduct a trial within a trial on the premise of Mbilingi having retracted the confession. So basically here, the purpose of the trial within the trial is test on the truthfulness of the confession. So once the prosecution wants to rely on the confession and the defense objects, you conduct what we call a trial within a trial. Then in the role play, as state attorney and defense attorney make oral submissions in a trial within a trial. So basically, these oral submissions are about the authenticity of the confession. Identify and address the issues arising from the trial processes above. The issues, of course, conflict of interest, not overcharging your client, proper due diligence, among others. So I think that was it. We can move to workshop 2. The aims of these workshops are to develop the ability to institute criminal cases before the High Court, develop skills necessary to lead and tender in evidence in court, develop the ability to prepare judgment, develop the ability to pass appropriate sentences, develop the ability to render appropriate sentences, identify and deal with issues. By the end of this workshop, you should be able to institute cases before the High Court, tender in different kinds of cases before the court, read the evidence of children before the court. So the evidence of children is what we call a viodire. So once court is faced with the evidence of a child, you must conduct what we call a viodire. So basically, a viodire is when you are trying to establish that this child understands the reason of taking oath, the intelligence about his surrounding, for purposes of him or her being able to give evidence. So present an aroctus after conviction. So we have aroctus and mitigation. Of course, aroctus, the state is saying that should be given a maximum sentence. Mitigation, the defense is saying no, he deserves the lighter sentence. Has been comparative. We have to look at the sentencing guidelines, which basically governs us into that. Then issues, we have discussed that already. So let me read the statement of the victim. The above particulars are minor, which state that during the night of 9th October at around 3 as I was in bed with my children at my home in Kempungu village, a certain man entered into my house. It seems that we forgot to lock or fasten the door because was not broken. It was dark and light were off. There was general road shading. So that means there is no breaking into, there is no burglary. The man came in and disguised themselves by speaking as though they were my husband. Mokombe Jacks, he just entered the bed and covered himself in the blanket. I later felt him removing my clothes. I bridged the act of sexual intercourse, but later on I felt that his voice was a little different. I tried to speak to him, not allay my fears, but he instead kept quiet and refused to speak to me again. I tried to see his face, but he hid in the blanket. So basically here we are dealing with rape. Because rape, the consent, because this consent was not the real one. You understand? It could the consent was withdrawn, but also the consent was fraud. Like it was fraudulent. There was a misrepresentation. So that's not the consent that is required. The intruder then tried to leave the house. When I tried to observe his face, I head onto the door, and ensuing a scuffle prompted my elder son, who was in the next room to intervene with a bright torch. The man gathered his clothes and tried to flee, but my son Mukombe Israel flashed the torch in the face of this man. I realized that it was not my husband, it was a man I had never seen before. So basically, this is here we shall also looking at the identification. Of course, we have looked at the loan identification. You have to take into consideration the source of light, the circumstances, the distance, and the time of the day. The man overpowered my son and ran out of house and left behind his cell phone on my bed and sandals under my bed. I reported the incident to our SC and he gave me a forwarding letter, and I have today came to report the matter to the police. So basically here we have rape. Let me look at the statement of the suspect. The above particulars and addresses are true and correct, and I do wish to say that it is not true that I entered the complainant's house. She just wants to frame me. Maybe she loves me. I was even not in that village that night. Alibi, like they always do. I was attending a music concert in Yanton. It's a lie. For me, I was unlucky when my phone was stolen from the concert, and I want to replace my SIM card. Since I have failed to trace it, it was not me. So he produces an alibi. We have medical examination of a victim of sexual assault, examination by medical officer. So the question is assuming the person of St. Anthony file and further produce the case file and do the following: identify the offenses, if any, disclosed by the facts, and evaluate the evidence in support of the possible offenses charges. So I can only see rape. In the event that you find the evidence sufficient to authorize documents, indictment and summary of the offense. Assume the role of the State Anthony read the evidence in chief of the Kwagara Analogus. So we have to read evidence in chief. Assume the role of the High Court judge by way of a demonstration. Proceed to conduct a preliminary examination of Mukombe Israel to test his competence before receiving his evidence in chief. So Mukombe Israel, I don't know, was he a minor? Let me first go back, but I think he's a minor. Mukombe Israel, so that would mean that we have to conduct what we call a viodaya. Yeah, Mukombe Israel is 13 years old. We have to conduct what we call a viodaya. As a high school judge, assuming that a prima facie case has been established in a role play demonstration, how you would proceed to put the chosen person to choose their defense. So you have to, of course, make a ruling. Then you put the choose defense. Basically, you have to make a ruling from the submissions and the evidence that was laid. Assuming that the chosen person has been found guilty and convicted in a role play, State Anthony and Defense Counsel demonstrate the Aroctas process. So the Aroctas process have mitigation and aggravating factors. The sentencing guidelines be guided as basically why the prosecution is praying that the accused would be given a heavier sentence, and why the defense is praying that the accused would be given a lighter sentence. As the High Court judge proceeds to impose an appropriate sentence in accordance with the law, of course it must be guided by the sentencing guidelines. Reduce all the days in remand. Identify the ethical issues arising from the trial processes above. Of course, we have conflict of interest, doing proper due diligence, not overcharging your clients, among others. So we see the case of Festo Asenoa versus Uganda. Festo Asenoa versus Uganda. It's a Lucas Classes case on confessions and what is it and how they can be admitted. Wellington versus DPP, Lucas Classes case on standard and burden of proof. The other case I can see here, Uganda versus Bulgaria Moses, I think it also discusses identification. Yeah, that's it. I was trying to see on Workshop City. So you have to basically prepare, because most of the oral questions always come from these workshops, like the way you see them here. So that's why it's very, very important that in your preparation you understand how to do these role plays, because they can ask you an oral question that assume that you counsel for the plaintiff, assume that you counsel for the state, and you're going to be relying on the medical report of the doctor. Please proceed and lead evidence for the medical doctor. So of course we are very aware that you can only lead evidence through the person who authored it. So once the first thing you do is, my lord, I'm counsel Patrick, counsel for the state, and we are ready to lead our first evidence in this matter. My lord, I will ask our witness to take the stand. Then the judge will tell you, please proceed. Then you will ask your witness to take the stand. So once your witness takes the stand and he or she reaches there, you ask the court clerk to administer him or her oath. So once the oath has been administered according to the Oaths Act, because you also have to understand what basically do you say, because they can say, please proceed and administer your client an oath. Then after that, you ask your client, can you please tell this honorable court your name? My name is David. Yeah, please, what do you do for a living? I'm a medical doctor. Where do you practice from? I practice in Mrago Hospital. So what were you doing on this date? On that date, I was attending the hospital. So what happened? They brought me a client to examine. What did you find out? I found out there were some bruises on his body. So how did you record that? I recorded that in the medical report. If I give you that report, would you be able to identify it? Yes, counsel, I can be able to identify it. How would you identify it? I would identify it because I appended my signatures and I dated it, and also there is a name of the hospital. Then you ask leave from court that through the clerk, I pray that the client be given this medical report. So is that the report you're talking about? Yes. How were you able to tell that? It has my signatures. What were the findings of the report? Can you identify the accused person in this court? Does the medical report implica the accused? Okay, then, my lord, the witness has successfully identified the document. I have nothing else to add. So just like that, then the court calls the opposite counsel where they have any cross-examination. And when the cross-examinations are taking place, you have to keep quiet, because remember, you have to examine. In instances where your client stammers, you have to come and clarify and say that counsel for the state asked you this and you said this. What exactly were you meaning? So you have to clarify, because when the witness is put on the hands of the opposite counsel, they tend to shake. So cross-examination is an art. I just pray that you practice it. You practice it, that's how you get better. But you must have a theory. You must have a theory, and here I mean that you must bring out something. You don't just ask questions. Like what I have said, I heard that one of the students says that I heard you said you are a person of sound mind. Yes. Can you please prove that? Because now how does that contribute to your case? Okay, so in case you have a mentorship program, we have a mentorship program. You can text me on 075 67 284 on WhatsApp. members pay monthly subscription fee, and we shall train you for orals. I believe that we shall leave no stone unturned. We shall make you confident and help you to cover a lot within the shortest possible time, and explain to you all these things that you understand them. So please, may you pass LDC with the first class. That's all I wish for you.